During the coronavirus lockdown, many companies are turning to their contracts to consider whether relief might be available under force majeure provisions. However, it is not just the global pandemic that is causing companies to consider this issue. We've had a number of queries as to whether the low oil price environment might entitle a company not to perform its obligations under a contract. Before taking any action, there are 5 things you should consider when looking at whether force majeure relief might be available under a contract. First, it's important to remember that force majeure provisions are solely a feature of contract in common law jurisdictions. Under a contract governed by the laws of a common law jurisdiction, such as England and Wales or New York, when it comes to all questions of contract interpretation, what really matters is the words on the page. That is not the case for agreements governed by the laws of a civil law jurisdiction, such as France, Germany or Spain, where the civil code will set out force majeure or relief against hardship principles that may supplement or vary the provisions set out in the contract. Second, just because a particular event is listed as one of the potential categories of force majeure in a contract, that doesn't mean that a company is automatically entitled to not perform those obligations. Most contracts provide that the event has to operate in a way that prevents the company from performing those obligations. So just because your contract lists pandemic, for example, as one possible category of force majeure, if the coronavirus situation has not impacted on a company's ability to perform its obligations, then it will not typically be entitled to relief under force majeure. The third thing you should keep in mind is that obligations to pay are not typically subject to force majeure relief. Even if you are entitled to force majeure relief otherwise, there is often an express carve-out for obligations to pay. That means that even if force majeure provisions apply to a contract, it won't relieve your payment obligations. This is often a critical issue. Fourth, other remedies may be available and are something that you should consider. Under English law, for example, it may be useful to consider the doctrine of frustration. In some US jurisdictions, there are similar principles of impracticability and impossibility. Finally, deciding to call force majeure shouldn't be done lightly. There are consequences of getting it wrong, including potential breach of contract claims. And for those companies hoping for some force majeure relief based on the low oil price, there's unlikely to be good news. Most force majeure provisions include an express carve-out for oil price and other commodity prices. For more information on force majeure or other questions relating to coronavirus, go to our COVID-19 Resource Centre at bracewell.com.